So before we start, I'd like to acknowledge the traditional custodians of the land that we are all broadcasting from today and pay our respects to elders past and present. And also, because this is an education session, I'd like to acknowledge that Aboriginal people are the first educators on this land. So I'm going to ask Alima and Josh to introduce themselves, and then I'll tell you briefly sort of what we'll be talking about today. And we've got a lot to cover, so I'll hand over to Alima and Josh if you just want to introduce yourselves. Before you do that, some people have said they can't hear. It sounds like most people can. There might be some audio settings to try on your own device, or your mute or select headset or computer audio. That's about all I can offer people today. Sorry, Alima, over to you.
Sorry, that's okay. My name's Prem Alima. I'm the solicitor in charge of Legal Aid's Child Support Service, and I normally work in Parramatta, but I'm broadcasting from Erskineville today.
Hello, everyone. I'm a solicitor. I work in the Child Support Service at Legal Aid as well. I'm based in the office just opposite Alima's, but at the moment working from home as well in Western Sydney.
Thanks very much. So you can see on your screen today the topics that we will be covering. We do have a lot of people joining today, so we do want to encourage you to ask questions, and only we can see the questions, not everyone can. So we do encourage it, and we'll try and get to your questions during the webinar, or as I said, afterwards. So what we'll be covering is talking about the Legal Aid Child Support Service, where Alima and Josh work, the child support scheme, paternity matters, Centrelink and child support, the child support formula, collecting child support, administrative remedies, child support agreements, court applications and appeals, other child support issues, and we have a case study at the end and some questions for you. So as you can see, there is a lot to cover. And before I hand over to Alima, we just have one more poll just to find out who is in our virtual room. And we just want to get a sense from you, how often does the topic of child support come up in your interactions with clients? Is it daily, weekly, monthly, rarely, or not at all? So this is just to give us an idea of how much this occurs in your work. Looks like a few people are still. Okay, I'm going to close that now and share that with everyone. So Alima and Josh, can you see there on your screen that?
Yep.
Yeah, it comes up quite a lot. So for more than half of the people, it's daily or weekly. And for many more people, it's monthly. So it is obviously, people are in the right spot. It's a very important issue. Did you have any comments on that, Alima or Josh?
Well, my comment is that for Josh and me, it comes up all day, every day.
True. Good.
So it's good to see that other people are interested, and we're very grateful that they've joined us today to learn a bit more, and hopefully it will make your interactions with clients easier in future. I'll just first talk about our service. We're a unit within Legal Aid's Family Law Division. There are a small group of solicitors, about 7 of us, who specialise in child support matters. We give advice, we represent clients who are eligible for a grant of aid, we do a duty service at some of the courts. Our advice services are free. We also do community legal education. If people need representation in court or a tribunal for a child support matter, they'd need to get a grant of aid, but otherwise they can get free advice by calling our service and making an appointment. We'll have details at the end if you want to refer someone to us. I'll talk a little bit about the child support scheme generally. The child support scheme is it covers all children in Australia and some children overseas if there's a connection with Australia. The scheme started in the late 1980s and it now replaces pretty much the family court system for deciding how much child support's transferred between parents. One of the principal ideas behind the scheme is that parents are responsible for supporting their children, and that's not changed by whether they were married or in a de facto relationship, or even if they never lived together. The parents' responsibility to support the children continues even though the relationship between the parents might not be ongoing, and their obligation to support children doesn't stop if they repartner or if they remarry. The way that child support works is that parents can apply for a child support assessment. The assessment applications are made to part of what's called Services Australia now, but most people still refer to them as the Child Support Agency. And Child Support Agency's job is to assess how much child support is paid, to collect and enforce that if that's requested by the parent who has primary care of the child. The application form for the child support assessment, can we have the next slide? It's available on the Services Australia website. This is what it looks like, and you can see there I'm a new customer, and if you click on that, behind that is an application form. It usually only takes about 20 minutes to put in an application. Most people can do that quite simply themselves, but if someone has problems putting in an online application, they can ring child support, and if it's clear that applying online would be difficult for them, child support can do an application over the telephone. Next slide. One of the issues that we often get questions about is paternity. Child support, in order to accept an application for child support, needs to have satisfactory proof that someone is a father. Now, that doesn't have to be a DNA test in every case. Parents can be accepted to be a parent if they're named on the child's birth certificate. Child support can also be satisfied by evidence that the parties were married when the child was born. A parent can execute a statutory declaration acknowledging that they're a parent of the child. It's also possible to be satisfied that someone is a parent if there's evidence that the parties cohabited at some time and lived together, that is, in a period 20 to 44 weeks before the child was born. It doesn't have to be all of that period, it has to be some time within that period. And another form of proof of parentage that child support can accept is a court order declaring that someone is the parent. Now, if a mother has a child but they don't have suitable proof, if they make their application to child support, that won't be accepted first up. But it's still important that they can apply, because there's a requirement that they take reasonable maintenance action if mum is going to get some family tax benefit from Centrelink. If the application is refused, legal aid might be available for court proceedings to get proof of paternity, and that might involve DNA testing. And grants of aid would cover the DNA testing if the person is eligible under our means test. There's also sometimes people have been accepted as a parent, usually the dad, but they don't think they are. The person who's assessed to pay child support but doesn't believe that they are the father can apply to the court for a declaration. In the course of those proceedings, it's possible that the court might order a DNA parentage test. DNA parentage test, the court can't make people participate, but if they don't participate, the court might draw some conclusions that they're not participating because they think it'll show something that they don't want to know. So I think it's important that people come and get legal advice about whether they need DNA parentage testing, and if not, what their options are to apply for a child support assessment, and possibly even to end it if both parents know that the person isn't actually the father of the child. If people want to apply to court about parentage, like an application for a child support declaration, there is a time limit. They need to act fairly quickly. It's a 56-day time limit to apply once child support either accepts or refuses the application. The court can extend that time limit if it's necessary to do justice in the particular case. I just mentioned DNA testing briefly here. I'm not going to tell you how it medically works and what the science is behind it, because I don't really understand it that well myself. But what I do understand is that it's not a great idea for people to run off and get one on the internet without telling the other parent. It can do terrible damage to children and family relationships if that sort of thing is done secretly, and the courts don't like it very much either. There are particular laboratories that are approved under the regulations by the court to conduct parentage testing, and it's usually better to get a court order for that, because then the results of the test would be admissible in court proceedings if required. I'll just talk a little bit more about Centrelink and child support. Next slide. I mentioned just quickly that there's a requirement to take reasonable maintenance action for family tax benefit that's paid by child support. We find typically that when people recently separate or when a new baby's been born, the mother is quite frequently reliant on Centrelink payments to some extent for the support of the household. So it's really important to consider how getting or not getting child support will affect your entitlement to Centrelink if that's your main source of income. There's a 13-week period that Centrelink allows before they will reduce someone's family tax benefit if they don't have a child support assessment. It's important that people apply within that 13-week period, and if their application is refused, they need to act fairly quickly to take further action to get some proof of parentage, and getting legal advice is a first step in that process. If the application for child support is accepted, there's enough proof of parentage and child support makes the assessment, the amount of family tax benefit that's paid to the person is adjusted according to the amount of child support that they receive. But you're always better off overall getting child support than you would be to just get a Centrelink payment. There are real positive incentives for people to apply for a child support assessment. If someone's in a situation where they're concerned that applying for child support might put themselves and the children perhaps in a difficult or dangerous position, if they've got a fear of family violence, they can talk to Centrelink about getting an exemption from having to apply for child support. The circumstances that an exemption can be granted in are quite broad, but some of the grounds are that the applicant parent fears violence or threats from the other parent. It might be emotionally harmful or disruptive to seek child support, depending on a range of factors that could be social or the circumstances in which the child was conceived. And another possible ground for exemption is the other parent is just not known. If the person can't identify or doesn't have enough information to identify the other parent, then they may be able to get an exemption. And also you might be able to get an exemption if you've tried really hard to locate the other parent but have just failed after a number of attempts. We can give advice about getting exemptions, but often a good point of contact is to ask to speak to a social worker at the Centrelink office, and they can often deal with that for someone. I think it's important, though, that people realise that when they ask for an exemption, they're just not going to get any child support at all until they change their minds and later apply for child support. And if you change your mind, the new application that you make will only start from the date that you apply. You can't come back and say, I'd like to get child support for all that period. But we think it's a good idea for people to keep thinking about whether they feel safe enough to apply for child support, because it's usually better overall for them financially. I've talked about applying for the assessment. I haven't really talked about how child support works out, how much is paid. The next slide's just a little picture of a child with a calculator. It's almost child's play to apply for a child support assessment, and although the formula is hugely complicated to work out yourself on paper, what happens is that child support just gets some simple information and punches it in, and the numbers then produce the amount of child support. The factors that they take into account are the costs of children, which are worked out in tables in the child support legislation according to the age and number of children. It's based on research on what parents tend to typically spend on their children across different income brackets. So it's not the cost of supporting your children, but it's the cost of supporting children according to research. The next important factor is the income of each parent. That's based on their last taxable income, so the income for the last year of tax that ended, and that's available for child support from the tax office immediately. The parents don't have to know how much the other person's income is. And then the other factor that they need to know is the level of care, and that is how many nights per week or per month or per fortnight do the children regularly spend in the household of each parent. That's worked out as a percentage, and those three figures, including plus the ages of the children, will produce a formula assessment of how much child support should be transferred in that particular case. Now, I've told you what the factors are. You don't really have to remember them, but I want to show you something really cool on the next slide, which is on the Services Australia website. It's the Child Support Estimator. You can see some tabs across the top where you put parents, income, children, results, and what if. So it just works by clicking on the tabs. You write in some names or made up names for the parents. It's not recorded anywhere. Income figures for each of the parents. So you might know your own income exactly. You might want to put in a guess for the other parent if you don't know. You put in the children's ages. You also put in the number of nights the children spend in each household, and then you get the results. And then the what if is where you say, what happens if the kids decide to spend an extra night a week at dad's house? What happens if dad starts earning an extra 20,000? What happens if mum has another child? And you can work through what happens, how does the formula adjust to different circumstances. I really encourage you to use that or to show it to clients if they've got concerns about how much they might have to pay or what will happen if my situation alters. Okay, so that's child support and how it's worked out. The next thing I'll talk about is collecting child support. This is something that we actually speak to a lot of people about. The big thing to know is that child support doesn't have to collect every case where it makes an assessment. Parents are able to choose whether to be private collect or agency collect. When I say parents are able to choose, if they can't agree on that, then the person who makes that choice is the person who's entitled to receive the payments. So when the application is first made, the payee, the person who's entitled to receive payments, can ask child support to collect for them, and we'll call that agency collect. If they want to use private collect, they just say they want to collect that money privately. If you choose private collection, that means the CSA takes no role at all in collecting the money from the other party. It's left up to the parents to arrange how it's transferred. The CSA doesn't monitor how much is transferred. It's not going to ask to see receipts. It's truly a matter between the parents for the transfer of that payment. And if the payments aren't made, child support won't know about it. But if the payee chooses agency collect, what happens is the CSA sends out notices every month saying this is how much you've got to pay. They'll charge penalties if the payments aren't made on time. The payments have to be made to CSA, not to the other parent. And then the CSA will transfer any money that it collects straight to the parent who has care of the child, that is the payee. Currently around 50% of child support cases are CSA collect and the other 50% are private collect. This is quite a change. When the scheme first started, it was almost compulsory for people to have the agency to collect payments for them. But nowadays, the CSA encourages parents to choose private collect as long as they've got a reasonable relationship with the other parent and they're able to contact them and make arrangements for those payments to be transferred. But it's really important for people to remember that despite how much encouragement CSA might give you, it's your choice. You're entitled to choose whether you want to collect or have CSA collect it for you. One of the things about private collect is CSA will often suggest that it's quicker to do payments that way. Certainly it is. If payments are going to be made on time and someone has the other parent's bank account details and they can just transfer through the payments, yes, that cuts out the delays of having the payments go through the agency. But it's really not a safe choice if there's going to be problems because of family violence, because of financial control, or if the person just doesn't feel confident and comfortable that the payments will be made on time. It's also not really appropriate for people to have private collect if the assessment isn't certain. If it's going to be going up and down and they're not certain that the payments are correct and the person doesn't have their tax returns lodged, it may be better to use CSA Collect because they can collect arrears if they're assessed further into the future. Now, once you make that choice about private collect and agency collect, you're not stuck with it. You can change it quite simply. And if you're an agency collect client and the payments are all going very smoothly and you're getting along with the other parent and you want to have a go at collecting privately, you just ring them up and tell them to stop collecting and you'll do it yourself in future. You can change your mind later if that doesn't work out and the payments fall behind. The only time CSA won't accept that election to switch from private collect to agency collect is if the payments are all up to date and there's no problems between the parents. But usually people don't ask for that if everything's going smoothly, so I haven't seen any cases where that's occurred. Another issue about private collect and agency collect is it has a different impact on your Centrelink payments. For the payee, I mentioned that you can choose to have private collect, and if you choose private collect, nobody's going to check whether you're receiving your payments on time. They won't check if you're receiving them, but Centrelink will assume that you are, and your family tax benefit will be worked out on the basis that you're actually getting all of your child support every month on time. If you don't get it every month on time, your choice is to start asking child support to collect it for you. You can't ask Centrelink to give you extra family tax benefit unless you also ask CSA to start collecting for you. So overall, I'd just like people to remember that private collect is fine, but it's usually only fine if you're getting the money. If you're not getting the money, you might be missing out on Centrelink payments as well as missing out on some child support payments. Now, child support does affect the amount of Centrelink payment that you're receiving, the amount of family tax benefit. It's not assessed in the same way as ordinary income, the way that they would work out family tax benefit based on salary or wages. But there is a maintenance income-free area, which is around about $30 to $40 a week. And any child support you receive above that amount reduces your family tax benefit Part A by 50 cents in the dollar. The important thing to remember is that you will never get less overall if you're getting child support plus family tax benefit, because the family tax benefit Part A can only be reduced down to the base rate. That's a really complicated thing to understand, but I think the messages are you're better off overall getting child support, and if it's not being paid to you, you should ask CSA to collect it, because the impacts on your family tax benefit are much better if you're regularly receiving those payments. For people who are having child support agency collect the payments for them, their family tax benefit can be worked out in two different ways. I'm going to just cover those very quickly now. If anybody wants more information, please go to the workbook that we've included as a handout, because you probably need to read it about 17 times before it makes any sense. Child support tells Centrelink two things. It tells people, it tells Centrelink how much child support someone is entitled to receive, and it also tells them how much it collected for them. If child support is collecting and the payments aren't coming through on time, child support will try and collect them in the future, but while you're not getting them now, probably it's a good idea to ask Centrelink if they can assess your family tax benefit on what's called the disbursement method, which means according to the amount of child support you actually got. Now, this is only available to people who are agency collect. If the payments aren't being made on time and you're finding it hard to budget, it's probably a good idea to have a chat to Centrelink about whether you can be paid some extra family tax benefit while your child support isn't being paid. If your child support isn't coming through and you're supposed to be collecting it privately, you probably need to ask for CSA to start collecting, and you might also need to talk to Centrelink about adjusting your FTB. Again, go to the workbook. It's really hard to explain. It takes all of our solicitors a long time to understand it, and it takes us a long time to be able to explain it well, and I still don't know how to do it. But it is an important thing for people to understand, because it's about having money to pay for food, shoes, and all the stuff that you need to support kids. I mentioned that if someone asks child support to collect the payments for them, the payments are supposed to be made to the agency. If people don't pay child support and they start buying things for the kids and think they can just deduct it from the child support, they're probably going to get in trouble. They might end up having to pay twice. So our advice to people who have a child support collect case is that you should pay the money to the child support agency. In very limited circumstances, if you and the other parent make an arrangement where you'll hand over some cash, you can report that to child support agency and they might be able to credit it, but only if you've got evidence that both of you thought at the time the money was handed over that both of you meant that it would be deducted from the money that you're supposed to pay to child support. These are called non-agency payments. I think it's a really good idea for people to talk to child support before they make them, because if they don't credit them, you're out of pocket and you still owe the money to the child support agency. There are also some things that you can buy or pay for to third parties that might be able to be credited as prescribed NAPs. Those include school fees and things like uniforms and books. But again, the rules are really complicated. It's not safe to assume that you'll be able to do that, and talk to child support before you make such a payment. Don't assume that it can be automatically credited. I'll just talk quickly about how child support enforces payments. I said before that they send people bills and they charge them penalties if they don't pay them. Sometimes people don't pay. They're given an opportunity to pay directly to child support in the first instance, but if the payments aren't made on time and regularly, child support has some enforcement options that it can use without having to go to court. It's one of the reasons why the agency was set up, to make it easier to enforce child support payments and to reduce the number of times where people have to go to court about child support. So some of the things child support can do without going to court to collect money from people who might not be willing to pay include direct deductions from salary or wages, direct deductions from Centrelink benefits, although that's capped at an amount that means that the person still has something to live on. Same goes with salary and wages. There's a capped amount that that people have to be left with after their child support is deducted so that they can support themselves. If child support knows that someone's got money sitting in a bank account, or if they're owed money as a contractor by someone else, they can send a notice to that person, an administrative notice that requires the person or the bank to send what they are holding for the credit of the person who has the child support debt to the CSA in satisfaction of their child support liability. Child support can also intercept tax refunds that might become payable to the payer if they've got overdue child support. And in certain cases, child support can issue a departure prohibition order that stops people from leaving the country while they've got a child support debt. The departure prohibition orders have to be made and issued to the person. They're in writing. It's not a matter of you can't go overseas if you haven't got child support, if you haven't paid all your child support, but you won't be able to go overseas if a departure prohibition order has been issued, and those are issued for people who have persistently and unreasonably failed to pay their child support over a long period of time. The last thing that I will mention for enforcement of child support is that child support can take people to court if they've got an outstanding child support debt. Those proceedings are not very common. They only happen in a few cases, and only where there's something that child support is confident that they can seize or sell in order to recover the child support. So It's possible that if a payer hasn't paid their child support but they own a house or perhaps a business or expensive assets like a luxury car, child support might start proceedings to recover the debt by selling those amounts. But I have to say that that doesn't happen very often. I think the numbers have been getting quite low for child support to take enforcement action. I think perhaps less than 10 cases last year. Generally, they rely on their administrative powers of enforcement, and departure prohibition orders have proved to be a really successful way of encouraging people to pay child support when they might otherwise not want to. However, I think that COVID-19 has probably made those a less successful enforcement tool right now. We'll have to see how they go into the future. If someone has had a departure of prohibition order made against them, they can seek to challenge or have the departure prohibition order revoked. And they can also ask for a departure authorisation certificate if there are compelling reasons why they need to travel overseas temporarily. It's a good idea for people to come and get legal advice about that and to do so quickly. In general, though, child support's very reluctant to revoke a departure prohibition order until someone's paid off the debt. I think I've covered what I was going to do. Joshua, it's your turn.
Yes.
I might just pause there and ask a few questions. So one question we've had, Alima, is coming back to family violence. So if somebody has been in a family violence situation and has not applied for child support because of that, if the situation changes and they feel safe or family violence is no longer present, can they backdate?
Unfortunately, no. No, but that's a fantastic question. When we see people who are in this situation, we try and encourage them to think every now and then, do I feel safe? Have things changed? Can I apply now? But your application is only for from the date that you put the new application in. So you'll have foregone the child support for that earlier period, but putting your application in as soon as you feel safe is a great idea. You know, it might be that you've moved houses, you've moved towns, or, you know, things have just settled down and you feel like you now can do it while feeling safe. Make that application to child support as soon as you feel comfortable. It's getting an exemption from having to apply for child support is an exemption from needing to do it. It doesn't stop you from doing it. So it doesn't matter if Centrelink has said you don't have to apply ever, or if Centrelink have said you don't have to apply for 12 months. As soon as you feel comfortable, apply again, and it only starts from the date you make that next application.
Okay, now we've got a question about when people are doing their taxes. So what happens when someone has not done their tax return or reported their income for some time? When they get round to doing their taxes, will the assessment for the previous years be considered?
That's a super question, actually. There are two things that people need to know. One is that you're supposed to lodge your tax return every year if you're a child support client, even if your income is below what is the tax threshold. There's actually an obligation to lodge even if you're below the threshold if you're a child support client. If you don't lodge for a number of years, the way it works is not in your favour, to be honest. If your income is lower than what child support has used, they're not going to give you change. They're not going to go backdate and say, hey, here's some child support that you didn't need to pay. If your income is higher, though, they're going to go back and ask you to pay the extra child support based on that. So it's not going to be a long-term successful plan to avoid child support if you don't lodge tax returns. It might work for a while, but we see quite a few people who haven't lodged for a long time who assumed when they did they would get their debt would go down, and that doesn't work. It doesn't go down. You might have to go to court, or it might even be too late and you might be stuck with paying child support based on what child support thought your income probably was.
Thanks, Alima. There's quite a few more questions, which I think we'll come to after, because this next part on administrative remedies might cover some of those. There's just one more question on around family violence that I wanted to ask you before we move on. So
Yes.
if there is family violence, is there any way that the payer would know the payee's home address through the child support process?
Only if there was a terrible, terrible breakdown of procedure. Everyone who works in child support, and I did used to work there quite a few years ago, has it drilled into them that this is really sensitive information. These are really sensitive circumstances. They're not allowed to tell people the address of the other party. It's not included on any letters. If the person asked, could you, tell me where my partner lives, it's really important I speak to her or him, they'd be told, no, we're not allowed to for privacy. Privacy is a word that crops up a lot when you talk to child support. No, they won't pass your address on. It's drilled into staff so importantly that they do not pass this information on. I'd be really very surprised if that happened.
Thanks. All right, there are a few more questions, but we'll move on to Josh now, and some of those questions may be answered or we'll come to them at the end. So thanks, Josh.
No, all good. Thanks, Alima, for all of that golden information. I'll try to keep my part fairly short. The first thing I wanted to talk about is basically how to update child support if circumstances change. So the first sort of point is about updating income. So generally speaking, child support uses, I guess I'm assuming, like child support assumes people have put their tax in on time, and they'll use that information. So it'll be the previous year's return that they'll be using. Of course, if someone then might become unemployed during that time, what they have to do is they can contact child support, they can make an estimate of income, and then child support will issue a new assessment, and that'll be based on the current year of income. Now, a trap for young players is that at the end of the financial year, child support will then reconcile the estimate. So it's very important that clients are accurate, parents are accurate when they give their estimates of income. We see a lot of people that fall into this trap of, it might be because their hours of work vary, but they just don't give reliable estimates. And then at the end of the year, they end up with a child support debt when the reconciliation happens. So likewise, we see people who've given estimates and they've never put their tax return in. Eventually, it will be reconciled, even if it's 10 years later when they put their return in. So it's something that you just need to be careful about. The other thing that will change and will affect assessments is care. So if the level of care changes, or if the nights that parents have with their kids changes, again, they just need to call up child support to report those changes in care. And the way care works is that it's, some changes won't affect care. It's based on different brackets of care. For example, the first bracket, 0 to 14%, or up to 52 nights of care. If someone, for example, is reporting a change which will be 10 extra days, that may not put them into the next bracket. It's still important, though, that they update the care. And also the important thing is that you can't really backdate changes to care very easily. So people need to report the changes when they happen, or it might not be properly recognized in the assessment later on. So the next topic, and we see a lot of clients that apply for this, so this is something we advise people on a lot, is change of assessment. So there are a lot of circumstances that child support don't take into account, and that's kind of what this change of assessment in special circumstances is there for. So there are 10 different reasons that you can, grounds to apply for a change of assessment. Those things include things like if a child has special needs, special medical costs above and beyond, I guess, what most people would have, that, but it does include orthodontic costs, could fall within that. Costs of private schooling, that's another special circumstance. And also if parents are paying a lot to spend time with their kids, perhaps paying for flights to and from interstate, that isn't normally taken into account in a normal assessment. So that could also be a special circumstance. And the process, it's an adversarial process. So even though child support do have the power to investigate circumstances, they're going to rely on the parents to provide the information. So and then the other person will have the opportunity to provide their own evidence. It'll take about, in our experience, takes a few months for them to make a decision. And I guess once they make that decision, I'll move on to the next topic, which is reviewing CSA decisions. So most decisions that child support make can be reviewed. The internal review process is called an objection. So if someone, say, wanted to dispute a care decision or maybe a change of assessment decision, whatever it is, they've got 28 days from the date of that decision to put in an objection. You can do an objection over the phone, but there's also a standard form available on the child support website that you can use to put in objection as well. And then there's a second review as well. If clients are not happy with that objection decision, they can then apply for a further review to the Administrative Appeals Tribunal. So they get one review for most decisions, but for care decisions, there's actually a second merit review process. And in these reviews, you don't need to point to anything being wrong with the decision below. The client can provide new evidence and details and basically just ask for a reconsideration. So I'll just move on to the next point.
Yep.
Yeah.
Josh, we've got quite a lot of questions. Just a few. Is it quick to explain? You said the different levels of care, there's 0 to 14%. Is it quick to describe what the other levels are?
Yes, sure. So I don't know all of them off the top of my head, but I think the next two are, so I think 14 to 35 is regular care. That's the next bracket. And then after that, I think is 35 to 65, which is shared care. And then beyond that, you move into primary care is the next bracket. Okay. So if one person's got like more than 65, that's considered primary care. But yeah, shared care is, so that bracket of shared care is a decent chunk. It's not exactly 50%, but 50% falls within what shared care would be.
Okay, and we've got quite a few other questions around and a change of assessment. If someone has a change of assessment application on foot for special circumstances and they know that the other parent has money but isn't paying for private school fees, for example, is there anything that child support agency can do, or does that need to go to...
Yeah, no, so in this slide, I'm talking about where people can apply to child support. So this is an application to child support. So if the change you're asking for is about an assessment that's is less than 18 months old, or you're asking for a change to future assessments, the client can fill in the form, the change of assessment in special circumstances form, send that to child support. The private school fees will be taken into account. It doesn't mean necessarily that whole expense will be covered, but they'll probably decide to adjust or increase the amount of child support payable. I don't know if this was hinted at, but another situation we see a lot with change of assessment is where someone has, so normally you get the income based on what's declared with the ATO. We often see a lot of perhaps mothers approach us where the father has declared a very low income. She has information to suggest he actually has a much greater income than that. So that's another situation where you could use change of assessment so that they look behind his income and they could adjust his income and therefore increase what he's liable to pay. So there's a lot to change of assessments. And again, that's something we frequently deal with. And if you want to know a bit more about it, it's probably enough to cover another hour just on that. But you can, if you look at the actual change of assessment in special circumstances form, it provides a good description of all 10 grounds and what is required to meet those different special circumstances. So I'd encourage you to have a look at that. And if you're a lawyer, there's the child support guide, and it provides a lot of detail as well. about
Thanks, Josh.
change of assessment. Sorry.
We might move on because there's still a lot to do, and I think some people's questions will be covered in our case studies, so we might make sure we get to that. So child support agreements.
No problem. Okay, so I'll try to cover this pretty quickly. So I just wanted to quickly touch on the two types of agreements that child support will recognize. So the first is a limited agreement, and the second is a binding agreement. So a limited child support agreement is where the parents have a written agreement where they've agreed to pay the assessment amount plus something on top of that. So that's a limited agreement. And there's actually a really good template form available. And our workbook goes into a lot more details about agreements too, pages 14 to 17. So a binding agreement is parents can do whatever they want with a binding agreement. So for example, they could agree to pay no child support. That could be a binding agreement. The difference with a binding agreement is you actually both parents need to get independent legal advice about the advantages and disadvantages. And for child support to accept it, there actually has to be a certificate annexed to the agreement showing that that advice has been given, signed by the lawyer that's given that advice. And I guess once you register, so once the agreement's actually given to child support, then whatever child support, then people's child support payments will be based on the agreement. We've unfortunately seen a lot of people where they don't give the agreement to child support. The important thing is to remember that until the agreement gets to child support, it hasn't been registered and it may not stop an assessment from being in place. So that's a small thing, but it's quite a critical thing. When an agreement is registered, child support will issue what's called a notional assessment. And the reason that a notional assessment is generated is, there's a couple of reasons, but one of them is because the notional assessment, which says what parents would have to pay if there was a child support assessment, that's used to calculate family tax benefit. And that's something parents can't contract out of, unfortunately. So that's something for people, parents who are on Centrelink and want to enter into a child support agreement should keep in mind. The other reason that a notional assessment is issued, and this sort of goes into the next topic where I'll be talking about how do you get out of an agreement, because that's what we see a lot of people about, is that with a limited agreement, so you can ask for a new notional assessment to be issued at any time. And if the new notional assessment has changed by more than 15% from the previous notional assessment, apologies, this is a bit confusing, you can then, the client can elect, they can contact child support and ask them to end a limited agreement. Another situation you can end a limited agreement in is if it's been more than 3 years since the date of the limited agreement. And I guess otherwise you can apply to court, and if there's been a substantial change in circumstances. With a binding agreement, it's a lot harder to get out of. Our experience is that it's very hard to demonstrate the type of change of circumstances necessary to get an agreement set aside for most people that we see. But again, it's a very technical issue, and it's something that clients should get some advice about. So I just want to move on now to the next topic, so I'm not spending too much time on that, but there's a lot more information about agreements in pages 14 to 17 of our booklet. So just quickly, I just want to go through a few court applications that we haven't already discussed. Alima's already talked about the fact that sometimes you need to go to court about parentage related matters if you need to get proof that someone's the father, to get an order that they're the father, or likewise to get proof that you're not the father. So other times you need to go to court. So I was talking about change of assessment before. Where you need to go to court for change of assessment is where you're wanting to change assessments that are more than 18 months old. So if you're wanting to change a child support assessment between 18 months and 7 years old, you have to go to court first. you can either ask the court to make the change, or you can ask the court to give permission for child support to make a change of assessment decision. The other time that you can ask the court to do a change of assessment type decision is where you've got something else on foot at the same time. So you might have a parenting application in court or a property application. You can also ask the court to make child support a change of assessment or departure order at the same time. And potentially you could also make a consent order about that too. And we've seen that happen previously. The other time you can go to court, which we've got here, is to set aside an agreement, but also to vary or discharge an agreement. And you can obviously also go to court to, so I talked about reviewing child support decisions. If you want to take it to court, you can, but obviously you'd need to show that there's been an error of law. The last thing I just want to touch here is about stay orders. So you can ask for a stay order. A stay order is basically any type of, so it could be to stay the assessment of child support. It could be to stay the enforcement of child support. It could vary the amount of child support that's meant to be paid for an interim period. But the thing with a stay order is it's only an interim or supporting order. There has to be some other type of application on foot to get a stay. So you'd have to have perhaps an application to set aside an agreement, or you'd have to have a change of assessment application either through child support or court to get a stay. Again, it's quite a technical matter, and it is something we talk to clients about, and we can talk them through what they need to do and what they need to establish to get a stay. Alima's already discussed about enforcing child support, so I won't repeat that. Okay.
I'm moving you on because there have been some questions about overseas. So if somebody moves overseas, so I'll let you answer these other child support questions, and then we've got our case study, which I'm really excited about.
Okay.
Thanks, John.
Okay, so I just want to quickly touch on these matters. So lump sum child support. So it obviously isn't the ordinary way, but it is something clients can apply for. If they've got an existing child support assessment, they could apply to court for a lump sum child support orders, and that could be for a property, for example, to be transferred in consideration of child support, either 100% or some percent. It's just a good option to be aware of, particularly for people that are experiencing domestic violence potentially, because if the child support's paid in a lump sum, it'll mean that there isn't that ongoing relationship. It's paid out, it's done, and parties can potentially move on. Another situation where it might be a good idea is if you've got a parent who might be planning to move to a jurisdiction which Australia doesn't have a legal relationship with, in which case collecting future child support is going to be a problem. So the next thing I just wanted to quickly touch on, over 18 maintenance. So generally speaking, a child support assessment ends when a child turns 18. I will just quickly note though that you can apply for the child support to continue while the child is going to secondary school. So say they turn 18 in term 1 of their last year of school, you can call up child support, put in an application form and say, can this go for the rest of the year? And that's an easy thing to do. That's administrative. But for anything else, you need to apply to court. So either the child, the adult, or the parent can apply for an over 18 maintenance order. And there are two situations where they can do that. One of them is to allow child to complete a course of study. So if they're going through some type of tertiary education, or where the child has an illness or disability. And obviously that's subject to whether they've got the capacity themselves to earn and if the other party has the capacity to pay. The only other thing I just wanted to note about that is that while a child can apply, if the parent who's looking after this over 18 child gets the maintenance order, that maintenance order can be registered with child support. if the order is made in favor of the child, it cannot be registered and it can't be enforced by child support. So that's just another thing to just be aware of. Okay, so last point. I'll try to cover this fairly quickly. Again, there's a bit more information about it in the handout about if someone lives overseas. But I think the takeaway is that there are circumstances where an assessment, there can be a child support assessment in Australia, even if the parent is, even if one of the parents is overseas. So, for example, you might have a situation where maybe the mother and child are living in a reciprocating jurisdiction like England, like the UK, and the child is an Australian citizen. In that situation, if the paying parent is still in Australia, the mother can apply for an assessment in Australia through the central authority in that overseas country, and there can be an assessment here. Likewise, if, say, the paying parent is the one who moves overseas, child support in Australia will continue the assessment provided they move to a reciprocating jurisdiction, such as New Zealand. Then they continue assess, and they can even transmit the debt to the reciprocating country, and the reciprocating country can take enforcement action. Obviously, if someone, and we've also seen situations where someone will move to a non-reciprocating country, and the child support assessment doesn't automatically end. That's just because child support won't know they've moved unless someone tells them. So I guess the takeaway is this is something we do deal with, and this is something we can help clients with if this comes up. So you can send them our way.
Thanks, Josh. There's just one more question about lump sum child support, and then we will move to our case study. So if somebody's only asset is super, can a super split or super be counted as a lump sum child support payment?
That's a very good question, but I don't think that power exists. It's something they're looking at changing, but at the moment, no, no, unfortunately.
Okay, thanks. So we are nearly at 2 o'clock, but we do have a case study which will explain, I think, some of the questions people have had about private arrangements for collecting child support and that kind of thing. So I'd encourage you to stay if you can. Otherwise, if you do have to leave, you can watch the recording part of our webinar on YouTube to just catch the end. So, but please do stay on for another few minutes if you can. Thanks, everyone. I'll just read out this case study. So we've got Katya and George are separated about 6 months ago. They have 2 children, now aged 8 and 10. Recently, they attended a mediation session at a family relationship centre to try and resolve parenting matters. Katya and George got along well at the session and made some great progress in the best interests of their children. They ended up signing a parenting plan that provided for them to have 50% care of their children. Just before the mediation ended, Katya said to George, "But what about my Centrelink payments? If you take half my payments, I can't get by." And George said, "I don't care. You can have the whole lot. Just don't go chasing me for child support. I can't pay it if we're both looking after the kids." So what issues do you see arising there? We're just going to do one final poll, and this poll is a bit trickier than the last ones you practice. What we're asking you to do is just tick the boxes that you think are true. So is it true that no child support is payable if parents have 50-50 care? Is it true that Katya and George can arrange whatever they like about child support if they both agree? Is it true that Katya can't get any child support from George after they've had that conversation? Is it true that George can ask Katya to sign a document saying that she won't apply for child support? And is it true that if Katya signs this, then the child support they must refuse any future child support applications? So just think about that situation. So we're just ticking what we think is true. And I'm going to close that now just because we're running out of time. So hopefully most of you have had a chance to think about those. I know that wasn't much time. All right, so Josh, what we have here is most people think it's true that Katya and George can arrange what they like about child support if they both agree. 12% people think no, there's no child support payable if parents have 50-50 care. And some people think it's true that George can ask Katya to sign a document that she won't apply for child support. And most people don't agree that that conversation means anything, I suppose, or that.
And
Yeah.
Natalie, I helpfully jotted down the answers for myself, and I don't know if Josh has them, so maybe I'll do
Okay.
these.
Yeah, Alima.
So, the first one, 12% of people thought no child support is payable if parents have 50-50 care. I'm not surprised 12% of people thought that. I'm actually surprised that the rest of you didn't, because the answer is that's not true. It's false. It depends on what the parent's income is. So 50-50 care doesn't mean no child support's payable. Might be payable by one parent to the other, depending on whose income is highest. The next question, Katya and George can arrange whatever they like about child support as long as they agree, true or false? That's true. Parents don't have to use child support agency or have an assessment, but Katya might get less family tax benefit if she doesn't have a child support assessment. So they can arrange what they like, but there might be implications, particularly for Katya and her household. The next one, Katya can't get any child support from G after this conversation. Nobody thought that was true. That's excellent. We do sometimes see people who think that's the case, though. It's false. Katya can apply for a child support assessment at any time without getting George's consent. If Katya signs a document saying that she won't apply for child support, that won't make any difference. So the 23% of people who thought that might protect George, that's not right. Katya can apply. Katya can apply at any time. Parents can't contract out of the scheme. They might be able to make a written child support agreement, but as George has explained, child support agreements can only be accepted by CSA if they meet formal requirements. And if Katya is going to agree to get $0 child support when she would otherwise be entitled to receive more than $0 of child support, child support can't accept a limited agreement. They could only accept a binding child support agreement. They'd both have to go and get certificates of independent legal advice. And there would be some Centrelink implications for Katya because there'd be a notional assessment. So what we thought we'd show you now is what we would say to Katya or George if they came to see us for legal advice after they had this conversation. The first thing we'd say to Katya and George is that 50-50 care doesn't necessarily mean no child support. If they thought that was fair, we'd say, well, how would you work out the cost of school fees, excursions, uniforms, shoes and clothing, haircuts, extracurricular activities? If there's no child support, who's going to pay for them? Do you have something that works out whether it's you, George, or you, Katya, and what will you do if that doesn't happen in the way that you thought? The next thing, if George is earning more than Katya, he would be assessed to transfer some child support. The next one, if Katya doesn't have a child support assessment, she'll only get the base rate of family tax benefit Part A. The next thing we'd cover is if Katya applies for child support but she chooses to collect it privately and then she doesn't get any from George, then Centrelink will assume she's collecting the full amount. The next topic, if they do want to make an agreement, we talk to them about what sort of agreements you could make, and we talk to them about the differences between them and how easy they are to get out of if things change. We'd tell them about certificates needed for that limited agreements can't be for less than the child support assessment, and we'd say a binding child support agreement would need a certificate of legal advice. We'd warn Katya particularly, but we probably also mentioned to George so he understands how it works, that Katya wouldn't get extra family tax benefit to make up for not getting child support, that a family tax benefit would be worked out on a notional assessment. And then we say to them, well, okay, if you're happy now while you've got this 50-50 arrangement, what happens if things change in the future? If you're going to make an agreement, you should make the agreement cover what's going to happen into the future, because if you think that no child support is fair when it's 50-50, what about if it turns out to be 2080, or if the children decide that they don't want to come to your house this month, or they only want to be there in the school holidays. How are you going to deal with that if your agreement doesn't reflect that situation? So that's an awful lot of stuff to cover when you have two people who think that they can just agree 50-50, no money changes hands. So that's why we like people to be referred to us before they start to negotiate an agreement.
Thanks, Salima. I think
It's a horrible moment. I thought I was on mute.
Because we've gone over time, we're just going to quickly run through some takeaway messages and how to contact you. And then there's a few more questions that people have asked. But I should just also say we've had over 100 people join us today during the webinar. So I apologise if we haven't reached your question, but we do have your email addresses, so we can also answer your questions after as well. So would one of you like to go through what are our key takeaway messages from this webinar?
Josh, do you want to do those?
Sure. I don't think so. Basically, I guess, yeah, no, sorry. So basically, yeah, so I think the takeaway is that if clients don't have a child support case, they might miss out on family tax benefit if they don't qualify for an exemption. If they ask child support to start, they should ask child support to start collecting if it's not being paid, because if they're doing private collect and they don't address that quickly, then it will make it very difficult to collect later on. Lodge tax returns on time, it's actually not going to help. People think in the short term, oh, I can get away with paying less, but ultimately it's really going to screw them over if they don't lodge their tax returns. So lodge them in time, make sure the income information is accurate. Get legal advice before negotiating a child support agreement. People will often say, oh, I don't need to pay for lawyers, I can do this limited agreement, but we see people, and there are a lot of things clients will not anticipate. So just get legal, send them to us, send them to somewhere they can get some legal advice before they sign an agreement that is hard to get out of. And I guess the other takeaway is all the issues we've talked about today, we do give advice about. Currently, there isn't any means test about the advice we give, but obviously it's more limited for certain people. But yeah, and those are our details.
Yep, so you can see on the screen there's an email address to contact the Child Support Service, admin.css@legalAid.nsw.gov.au, and there's a phone number for Sydney and regional 9633 9916 and 1800 451 784 for regional. And Alima, if people are listening from another state or territory, should they just contact their local legal aid?
The Legal Aid Commission in their state or territory is the best place to contact. Those numbers on there, we don't answer questions immediately when people ring. What they will get is you'll be offered an appointment for advice. And at the moment, all of our advice is being provided by telephone, and there's usually maybe a 2 to 3 day wait for an appointment. It's quite a quick thing. So please ring. Clients should be ready to give their details so that we can book them in and get a solicitor to speak to them about their problem.
Great, thank you. And just a reminder before you go that you have a handout. There should be a handout on that panel on the right-hand side of your screen, which has that brochure that you can see on the screen there for the Child Support Service, which will also be in the email you get after the webinar. And also there's a workbook, so a PDF of the workbook that you will need to download now if you want a copy of that before you go. So there are some questions. So that brings us to the end of the webinar. I know we have gone over, and I apologize for that, but there are a few questions. So if people have time to stay on for another couple of minutes, there are some questions. So I might just go through some that we've already got. Josh and Alima, if that's okay.
Mm-hmm. Yep, no, that's fine.
So from earlier on, people have been interested in the payment of arrears and how is that calculated? Let's see if there's one.
Okay, so for payment of arrears, it's for child support, for cases where child support agency is collecting. Your arrears, when you receive them, will be taken into account for your family tax benefit in the year you receive them. So if it's a private collect case and you're in arrears, child support has already told Centrelink what your entitlement was, and Centrelink has already taken into account whether they collected it for you or not, and there's nothing you can do about it except go to child support and ask them to start collecting. So when arrears are paid, if you're a child support collect case, they're taken into account in the year you receive them. If you're a private collect case, they're taken into account when you were supposed to get them, and if you manage to collect them later, they won't be taken into account a second time. But we don't see many people who manage to collect them later, unfortunately.
And one other question about the costs of children, so how that's calculated. So does that include not private schools, but schools, excursion,
It's
uniforms?
basic costs. It's basic costs for children in Australian households, and it doesn't include the cost of private school fees. It doesn't include expensive extracurricular activities. It's really basic costs, and anything else is not covered by the formula. Change of assessment might allow people to apply for an increase or a reduction if the payer is paying for some of those costs, but only for particular sorts of things, and usually only where the parents agree about those activities. So if one parent really wants a child to learn an instrument but the other doesn't, they can't expect extra child support to cover it. It's really for things that the parents agreed they wanted the children to do.
Okay. Well, I'm going to wrap it up there. There were some other questions about making private arrangements for payment, but I think we covered that really well in the case study. So thank you so much, Alima and Josh, for your time, and everyone for joining us today. I hope you learnt something new. It looks like from the comments people did learn a lot today. So thank you.